let's take a look at some of the cases that the Supreme Court is about to start looking at. Specifically, the ones that are clear examples of the courts expanding their power and circumventing the will of the people in order to erode policies that conservatives don't like. And I know legal stuff can be a little boring, which is why we will introduce each one with a really sexy title. Get your genitals ready! Or guy-on-guy weddings, mind you. Both hot. So, 303 Creative LLC v. Elenis is a free speech case wherein a web designer claimed that she should not be forced to create websites for same-sex weddings. The poor baby. Do the gay people want wedding websites? Is that gross and icky for you? How sad. The web designer, a woman named Lori Smith, argues that a Colorado law that says she must work with all people regardless of sexual orientation violates her First Amendment rights. Fun fact, she doesn't actually offer services to weddings, but says that she plans to. What I mean is that this is a completely hypothetical situation that she is fighting against, and we will get to that in a second. Also, a fun fact, while Smith and her attorneys are arguing this on the grounds of freedom of religion, the question SCOTUS has decided to look at is whether or not a law that compels an artist to speak or stay silent is a violation of freedom of speech, not religion. The case has reached the Supreme Court after the 10th Circuit Court of Appeals denied Smith's attempt to overturn a lower court's decision to throw out her case. The Circuit Court said that Colorado must protect the interests of marginalized groups under the Colorado Anti-Discrimination Act, which is actually the very same law that was in question a few years ago when that homophobic baker guy, he refused to make a wedding cake for that gay couple. Hey, what is going on in Colorado? Are you guys good? In that case, the court ruled that state officials had not properly considered the baker's religious beliefs, broadly siding with the baker over the gay couple. However, the decision specifically avoided providing a general ruling on whether a business can invoke religious freedoms to deny services to members of the LGBTQ community. If the court sides with Lori Smith in this case, it could open the door for any bigoted business owner to legally justify discriminating against LGBTQ people by citing religious protections, which would be, and correct me if I'm wrong here, bad. And to go back to Lori Smith and how her website doesn't actually offer services to weddings, well, it turns out that Smith is represented by the Alliance Defending Freedom Group, which happens to have represented that Colorado baker I mentioned earlier, which happens to be a full-blown anti-LGBTQ hate group. See, this is actually just a thing this group does. They go around the country supporting religious freedom cases that just so happen to mainly be about the right to discriminate against gay people, specifically the right to post Jim Crow-style signs telling LGBTQ people that they are not welcome. To be fair and or balanced, it's not always about gay people. The ADF also funded Hobby Lobby when they didn't want to give employees contraceptives. So that's neat. They're shitty in multiple ways. The Lori Smith situation is what's known as a test case, meaning a case that can then be used to make similar decisions across the country. Lori wasn't being harassed by some uppity gay couples demanding her service. She's not retaliating against oppression. It is, in fact, the opposite of that. Lori's case is being used to attack LGBTQ people in a preemptive way. Some people connected to the ADF include, but aren't limited to, Mike Pence, Jeff Sessions, and neat Amy Coney Barrett, who has spoken 5 times at an event run by the hate group. Hey now, that's some obvious bullshit. I sure hope this Amy Coney Barrett person isn't in charge of laws or some junk like that. There are other important cases coming up that deal with things like indigenous rights and affirmative action, cases like Holland v. Brackeen and Students for Fair Admissions, Inc. v. President and Fellows of Harvard. Those cases are a little more business as usual in the sense that they aren't clearly backed by a fucking hate group. But needless to say, there are a lot of human rights being put at the mercy of a group of people clearly planted by right-wing Christian fundamentalists. But oh boy, bad news, it's not just human rights that are on the line. Oh yeah, you get it, Earth. Get shocked. You love it. Sackett v. Environmental Protection Agency is, in short, a case deciding what exactly is the EPA's jurisdiction in relation to the Clean Water Act. So hot. The Earth is so incredibly dangerously hot. More specifically, this is about the EPA's jurisdiction in terms of wetlands. Wetlands are extremely important when it comes to a lot of things, but most notably, they act as sponges for surges of water. Getting rid of wetlands often leads to more flooding. They're also really important in terms of nature and junk. One assumes. Frogs are probably important. So for this and other reasons, the Clean Water Act has always been considered uniquely vague in terms of defining what specific waters the EPA can regulate. It's designed this way to give the EPA a lot of flexibility in making these determinations, because nature is unpredictable. And in theory, this flexibility helps everyone because it gives the EPA leeway when considering emerging technologies and businesses in a specific area. The vague terminology means they can handle things on a case-by-case basis. However, 14 years ago, Chantel and Michael Sackett purchased a residential lot near a lake in Idaho and used gravel and sand to fill the lot and get it ready for home construction. The EPA ordered the Sacketts to remove the fill and return the lot to its natural state, arguing that the lot contained wetlands. The Sacketts sued in 2008, and 14 years later, this case has been endlessly bouncing around the courts like a really fast tennis ball. Court! You like tennis? Ha! In fact, this is actually not the first time the Supreme Court has seen a case related to the Sacketts. Back in 2012, they ruled that the Sacketts could challenge this restriction. During that ruling, Justice Alito wrote in a concurring 2012 opinion that the reach of the Clean Water Act is notoriously unclear, and that Congress should provide a reasonably clear rule regarding the reach of the Clean Water Act. What this all means is that if the Supreme Court rules against the EPA, it could force them to redefine the areas regulated under the Clean Water Act. Potentially, that either means they will overshoot their jurisdiction or, more likely, be forced to not include a lot of wetland areas. That would no doubt create a ripple effect leading to, ruined ecosystems and flooding. So, I don't know, maybe it's better to let the Environmental Protection Agency decide what environment to protect. Of course, the Supreme Court aren't the biggest fans of the EPA. In fact, Neil Gorsuch's mother even ran the agency under Reagan and largely focused on budget cuts and limiting their power. They already ruled against the EPA this year, preventing the agency from setting carbon emission limits from the power industry in an effort to move them away from coal and oil. Considering how dire climate change is becoming, this was seen as a devastating attack on existence. But hey, what's a little human extinction when you have the Koch brothers paying your way? As in, 3 of the recent justices, Amy Coney Barrett, Neil Gorsuch, and Brett Kavanaugh, were backed by the Koch brothers advocacy group, Koch Industries being a company that heavily deals with coal and petroleum products. Their advocacy group has spent decades lobbying to limit environmental regulation for the single purpose of increasing their profits. Give them a bing if you haven't heard of them. And so what we're now seeing is their efforts paying off. Rich assholes who put their asshole friends in positions of power where they can make them even richer assholes at the expense of everyone else. Hey, thanks for watching that clip. Here's the evergreen end plate to ask you to like and subscribe. It's any day of the year where you are.